KNZR presents The Law with Tony Lee.
Good afternoon, everybody. I'm Tony Lee, and I'm so glad to be here with you. It's a really hot day out there, so any place that I can be where I'm inside, that's definitely a good day. Glad to have you here with us. We're going to talk about something that, I guess maybe some of us know a little about, others of us know nothing about it, and then still others think they know something, but maybe they don't, maybe they do, maybe they don't. We don't know, but we'll find out because we have a guest this afternoon who can tell us all things bail, especially the idea of zero bail. I'm sure you've heard about that. The whole idea that if a person gets arrested, they would not have to post a financial or a monetary bail in order to get out of jail. And we're going to find out more of how that works, where that process stands right now, whether or not if you got arrested or someone you know got arrested, what would they have to do? Would they have to post a monetary bail, or would they just be able to sign a paper and off they go? And we'll also find out if that applies to every crime or only certain crimes. So let's bring in our guest. It's Mr. Jeffrey Clayton. He's the executive director of the American Bail Coalition. Good afternoon, Jeff, from Colorado. Glad to have you make the trip on video all the way here to us. How are you?
Good afternoon. Thanks for having me on.
My pleasure. First of all, tell us a little about you. When I talk about bail, and we're going to talk about an assembly bill that was posted to see if anybody would vote for it or against it, and all of that sounds sort of like law. So tell me, what is the American Bail Association? What do they do?
Yeah, so the American Bail Coalition is a trade association of insurance companies who underwrite criminal bail bondsmen throughout the country. So when a criminal bail bondsman is posting a bond for somebody, we're guaranteeing that what's supposed to happen is going to happen, which is that the defendant, if they fail to appear in court, is returned to court, or that the bond is paid in full.
Mm-hmm. Now, the idea of having zero bail, it seems to me that if a person already broke the law, and I know that we're innocent until proven guilty, but assuming that person A has been arrested and charged with a crime of some sort, I guess in a way, I think he'd be the last person I'd want to trust personally to say, okay, he's going to show up. I just know he's going to show up just on his word. Was that a safe bet?
Well, it can be. I mean, this legislation that we're going to talk about, Senate Bill 262, is arbitrary because of how it draws the line between people. But in general, what a judge would do is say, okay, this person, he's never been in trouble before. He's got ties to the community. This is a low-level crime. Let's give him release on his own recognizance. However, same crime, let's say it's just a shoplifting, but this person has 12 prior felonies. They never show up. They're probably going to do it again. You don't trust them. Then you might say, well, you're going to have to post a bond. So we trust judges, and they have inherent power in California and everywhere to do this work. And that's important. And some people should get out on their own recognizance, and they do. And even in felony cases, less than a majority of felons in this country will be required to post a bond.
Now, a felon, no matter what the crime is, actually, I mean, the idea of being able to get out of jail, that allows a person to keep their job, to continue taking care of their family, if it's a female or a father who is a single father. I mean, it leaves them free in the community to continue the responsibilities that they've had, so they don't come back and discover, I've lost my house or my apartment because I couldn't pay the bail while I was in there going through this court process. And is that sort of the reason behind wanting a zero bail, so that everybody got that shot?
Well, yes and no. I mean, I think that they're really, by doing zero bail, you're overruling what judges would otherwise do in the cases where zero bail is imposed. So if a judge is going to do misdemeanor bail in some misdemeanor cases, which happens, if a judge is going to do some bail in some of these cases where it's zero bail, this Senate Bill 262 overrules that. And so I think that's the problem. Should some people get zero bail? Yes. And I think they do. And that's the art of what we're trying to do here, is sort people into the categories, and also to be faithful to the California Constitution, which says judges have to look at three things, which is the seriousness of the offense, the previous criminal record, and of course the probability of appearance. So that's what we're looking at, and that's what we want judges to do.
How is bail set? I mean, what's the determining factor in terms of how much? Is there a schedule that says if you do, let's say an armed robbery, you can set a bail between X dollar and Y dollar? Or, I mean, how does that work?
California is a bail schedule mandatory state, which means that the legislature has told every local group of judges that they have to set a bail schedule within that jurisdiction based on the crime that's alleged to have been committed. And those are temporary. And the California Supreme Court just talked about how that's a temporary thing until you see a judge. So over the weekend, you can post this bond. Now, a prosecutor can ask for an increase. Your lawyer, if you don't post it over the weekend, can ask for a decrease during that period of time. So in California, all bails are preset. And so sometimes judges will say, well, these crimes are too serious, so we'll have to have a judge see those. See that a lot in domestic violence, in other charges where they want people to cool off. Then in California, you go before a judge, you can assert you can't afford it, you can assert any factors you want, the constitutional factors, hey, I'm going to show up, hey, I'm not a risk, hey, this is a low-level charge, all the different arguments you want to make, and then a judge will then either lower the bond. And also, this is setting the conditions of release. For example, if you're on supervision or whatever, where they're going to have a GPS monitor and all that. And that process will happen when you see a judge in court.
Let's talk a little bit about Bill Suit 262. This is California Senate Bill 262. Is that still being considered, or has that already been decided as to what's going to happen with that?
It's up in the air right now. Obviously, we're in the midst of a national crime wave, so I don't know that loosening the bail system on repeat offenders is what people want right now. The hearing in the Assembly Public Safety Committee is on the 13th of July. We anticipate it'll probably sit all summer, and that they'll probably consider it in late August or early September as to whether the legislation is going to come out, this year.
What has your organization, let me look back and see if I can get the name of it correct, because I think I messed that up last time. The American Bail Coalition. What does the American Bail Coalition actually do? Do you want to get Senate Bill 262 passed, or do you want 262 to fail? What is the coalition's position?
We think 262 is not the answer to the bail problem in California that we've been trying to get the legislature to solve for a couple of different reasons. The main one is that this requires a refund of all bail premium, less a 5% premium if the person is found innocent, charges are not filed, or if they appear. And what's going to end up happening is that people are going to get stuck in jail because bail agents are not going to be able to bail people out. And if we know somebody's guilty, we can bail them out. If we know they're innocent, we can't, because we'll forfeit. And so that turns the presumption of innocence on its head. And I think that's going to be a major problem with this. The other thing is, we don't think that the legislature can set a bail, which is what they've done. They've said it's zero here, and then judges can set here. We just don't think they can do that constitutionally. And we think, really the better answer is to try to get better due process for some of these poor people, which is what the California Supreme Court told the legislature to do. And that's what we think, the legislature should do. And the final point is, I think we all know that the bail schedules in California are way too high. The bails in California are way too high, and we need to do something to lower them. And there was some legislation that would start, ratcheting them down over time, but something needs to happen, on that level. And that's what we've been advocating for the last 4 years.
Are you looking at other states that have already done this to see how it works in their states and using that as a model? Or are you just starting something brand new right here?
We are. I think, we compare the zero bail experiment of California, of New York, and what happened and the increases in crime that were associated with that, because people were just getting continually rearrested over and over, and they know they could get away with it, and a judge could never get involved with that. In terms of finding solutions, we do look to other states. I mean, you have many states where judges will set bail and we won't do this bail schedule thing, or we have more robust due process, like the neighbor to the east of California, Nevada, who has, a more robust front end due process, where we really want to make sure this person needs to do bail. And if they're going to stay in jail, we really, really want the prosecutor to prove the need for it as a solution. So, I think that's really the answer of what we need in California. And the California Supreme Court all but said that in the Humphrey cases. Legislature, go do something. Let's have some real due process in California, so that, you're not in jail solely because you can't afford it. It's because there's real reasons that prosecutor have been able to put the proof up on.
This is going to be sort of kind of a political question in a sense, because we're in that political time where people bring these issues up because of the various civic groups that are out there. But the question is there a racial component to this, in the sense that some people believe blacks are arrested at an unusually high ratio as compared to other ethnicities, and that they have the least likely ability to pay that bail once they're in the jail. Does that have anything to do with the people who sponsored this 262 bill wanting it to be zero bail?
Yeah, I think overrepresentation is sort of a general indictment of the entire system, and people will use that as a reason to, make whatever changes they want to make. The reality is that, bail is important constitutional right. It's not just, something else. It's an important constitutional right that allows people to get out of jail. And I think, we need to, we need to keep that. And if we get rid of the constitutional right to bail, what would happen? And we saw that in the federal system. When we went to the no money bail in the federal system, we've tripled pretrial incarceration. And the same arguments were made in 1983 before that system was failed. Well, there's too many people that can't afford bail and the system's wrong. So let's go to no bail. Let's allow the prosecutors to say, this guy's too dangerous, this guy's too dangerous, this guy's too dangerous. And we saw the impact of that, which is, like I said, you had 24% of people detained in 1984 when the law took effect. That's up around 75% now, where you have a 25% odds of getting out of jail. So we can replicate, if we try to replicate the same system, we'll end up harming the same people we want to protect. The final point I'll make is that bail reform in San Francisco under the Humphrey decision, a report came out, and really what we discovered is that the jail population is the same. And what we've done is some people are posting less bails, but we've doubled intensive supervision, which means the same people that we're concerned about that we think shouldn't have to post bail, we're hammering them with intensive supervision. So definitely there's a component, a racial component to it. I think my general answer to all this is, if you don't change the inputs of the system, you're not going to reform your way out of it. And that's just the reality, is that we need to make it victim centered and protect public safety. And again, I admit that there's overrepresentation, and you're not going to solve that by fixing the bail system.
Yeah. We're going to take a short break, and we'll come back. We'll do a station identification, and we'll continue our conversation and kind of try to understand a little more how this bail system works. Again, under the assumption that most of us who are listening to the show haven't gone through it. We've not had to post bail. We have no relatives that we've posted bail for, so we don't really know what the difference is. And I imagine most of us also assume that if a relative or myself or whoever should get arrested, we go with the presumed innocent before guilty kind of thing. So yeah, we want him out because we think that guy's not a criminal. He's just got, hanging with the wrong people or something. So we tend to kind of look at it that way, as opposed to the other side saying, hey, he's a crook, lock him up. I don't want him on the streets with me. And therein comes the bail system, where he can get out, or it's harder for him to get out. So he can still get out, but it's just harder to do. But we'll explore those things here coming up in just a second. My guest is Jeffrey Clayton. And Jeffrey is the executive director of the American Bail Coalition. And I'm sorry, I said association in the last segment. I apologize for that mistake. It is the American Bail Coalition. And we're talking about Senate Bill 262. And we'll be back. I'm Tony Lee. This is The Law on KNZR.
KNZR presents The Law with Tony Lee.
Jeffrey, there is a financial component to this on a couple of sides that I could see, at least anyway. One, you have the bail bond agents, and it sounds like this could very well put them out of work. Would it have an effect on them? Would it damage an industry that employs people?
Yeah, I think it would. I think, under this system, it would just be impossible to operate. It so frustrates the right for somebody to contract for bail that I just don't think it would happen. So I think these, agents certainly would go out of business in California, as would all their staffs and the people that work in the industry. But the reality is that, what we've seen nationally is we outperform 100% cash. So if you, Tony, if your bond's $100,000 and you post $100,000 cash, or if you use a bail agent and only post 10%, we outperform it. And it makes sense because we have arrest powers nationally. So, it harms the system, it harms the defendant because they have to pay 100%. It just doesn't work as well. And so not only would the agents go out, I think the service that we provide would go away too, which, would be a problem.
Yeah. Now, by the way, folks, if you do have a question or a comment that pertains to the subject matter, you can post that in the comment section. We'll be able to see it, and then we can bring that in and we can address that as well. So please feel free to do so. And again, on the idea of the money that is involved, it sounds to me like if you have a lot more people who are going home, not staying in jail, where they, of course, are supervised, then they have to be supervised to some extent on the street. So that means you're going to have probation officers, parole officers, or someone that's going to have to look after these people. So their workload gets demonstrably increased, and they may or may not be able to keep up. So they have to hire more of those people. Hence, our tax money is going to be drained. What have we thought about that?
Yeah, the San Francisco, you're dead on. The San Francisco example, I think, proved that, which is judges, when they go to bail, that's good. They will not go to intensive supervision because they'll go, well, this guy, if he doesn't show up, we'll get a bail agent, we'll get him back. And so even a small drop in the amount of bail imposed, like I said, 14% of defendants were intensely supervised. That went up to 28%. So now we're talking about a third of offenders we're going to intensely supervise. What will happen under Senate Bill 62 is judges will not have the power to do bail in the zero bail cases. They will hammer these defendants. And the county governments will be left holding the bag because they're not going to charge these defendants for their own supervision. That's going to go to the taxpayer, and they're going to end. And the other problem with all that is it's another dragnet, right? If we tell a person who's an alcoholic committing crimes to simply quit drinking during the pretrial period, they're not going to do it. They're going to fail. They're going to convict. We're continuing the cycle by doing that, and that's not going to be effective. But that's what we're going to see, in county governments, like I said, are going to be left holding the bag on that.
And then there's another problem of overcrowding, which is something I think we're dealing with now, certainly here in California. So how would that be affected?
Well, absolutely. I mean, you have, jail overcrowding, but if you're going to supervise people and violate them, you're going to increase your jail population. That's just inevitable. That's what you're going to do. The real answer to this jail crowding bail problem is speedier trials. I mean, the system is virtually broken down during COVID. We haven't had a jury trial. And, as one judge said, the most certain deterrent for crime is the swiftness of the justice. And you got these cases just sitting for way too long of people that are going to stay in jail a really long time. That's what's clogging up the system more so than the people that are just kind of cycling in and out.
I'm not sure, but I'm going to make a guess that there are people out there who going to jail does not scare them. That's not a big deal. In fact, I think there are people out there who look forward to that because it gives them a certain amount of street credibility. So whenever they do get out, they come back and they've got their teardrops on their eyes or whatever to say, well, I've been in jail. I don't know what those things mean. It's 1 year, 10 years or something, but they have a number of teardrops up there, and that gives them a little more power on the street. So they're not afraid to go to jail. They're not afraid to stay in jail, and they're seeing a lot of their friends. A lot of their friends are in there. Some of their relatives are in there. So they're still seeing all of these people. They're not really missing out on anything. So if we get to the point where we are overcrowding our jails and we're overburdening our system on the outside with the supervision, but we're also overburdening our system on the inside because now we need more jail space. We need more jail guards. Has that been brought up in the course of these discussions?
Not so much. I mean, I think, overcrowding is a constant concern. And I think you're right. People are not afraid of jail. I mean, I'll give you two examples on that. You can Google bail reform, it's lit. Because a guy literally said, bail reform, it's lit. I like to thank the New York Democrats from Albany for passing this law because I just got free bail on my 137th charge. Wow. The other one was in New Mexico, two thieves steal a bait car that the police had a camera in, and the police are pulling them over. And the one suspect says to the other, "Oh no, we're going to jail. I don't know what I'm going to do." And the guy's all broken up. And the other guy says, "Hey buddy, we're going to get an OR." And the guy says, "An OR? Yeah, we're going to get released on our own recognizance in a matter of an hour. So don't worry about it. Just do what the cop says. We'll go to jail and we'll be out stealing the car before they know it." And they were. And so, yeah, when you're in the system, people know, they find out, and that's what happens.
Yeah. So then we overburden our police forces as well, because now they're investigating and reinvestigating the same cases, the same people doing the same crimes over and over again, probably before the paperwork is dry on the first case. So, I mean, it doesn't seem to make sense.
It doesn't. The chiefs of police, executive director, or I think that one of the chiefs of police from last year gave an interview during the zero bail, and they had a guy in Alameda County that got out 7 times in the same day.
Oh boy.
So that tells you everything you need to know about this is, Judges have to say enough is enough, buddy, for today. You're posting a bail or that's it. And under this zero bail, they don't have the ability to do that because the legislature is literally saying it's zero. There's no deviation. There's no going up and down. It's zero.
So then who are the groups or the people who are in favor of doing all this when you consider all the negative things that could bring about? Who wants it?
Well, the list is kind of thin at this point. I mean, I think the ACLU of California and others who I think just see this as a kind of a social justice, larger issue. And I think it is. I think they're right. I think there needs to be a more robust right to bail in California that's not as heavily dependent on some of these high bonds. But the reality is there is not very much support for this really outside of those kind of limited criminal justice reform groups. There's very little support amongst any county officials. There's no law enforcement support, very little support amongst any prosecutors. So, I'm not really sure what they're thinking on this one. I think that the momentum is just not the same as it was last time to do Senate Bill 10. And of course, the voters just rejected Senate Bill 10. So I think most people are saying we need to let the dust dry on this and maybe find another solution.
Yeah, it seems like the pandemic had something to do with it in the sense that, we're all crammed into our homes and, there's not much activity going on. Then all of a sudden the lid is taken off of that and suddenly we have this boom in crime. Is it just my imagination or did that happen? People just all of a sudden, there's just a lot more crimes being committed.
Well, two things happened. One, everybody was at home, so they weren't seeing it. And you saw the poll in New York City. I mean, the will-be Democratic nominee is a former police captain. And the number one issue that people realized when they started going back to work was crime. And until they went back to work, they didn't see it. And so the president said, we have an 18-month surge in violent crime in this country, and it's a national emergency. And he's right. And he's right. And these types of policies, this is not the answer to this crime wave at all, because all this does is enable repeat criminals. They're the only ones that are going to benefit from this, because the judges would already let out the guy who's the one first timer who's probably innocent, this sort of thing. So that the only people that are going to benefit from this are the ones we don't want to benefit.
It seems to me that if we really look at our society, we've got more people and more condensed, in some of our larger cities. I guess you've got more people in the same square footage or mile than we had before. Does that increase the possibility that there's more crime?
Yeah,
we population see that density.
Yeah, I mean, I think population density really, but gangs operate in cities, and that's. I mean, look at what's happening in every major city in California. Look at what's happening in every major city in the United States. Is that gangs are taking over, and it's guns. And what's funny is that we blame gun dealers, and we're going to sick Merrick Garland on illegal gun dealers, but that's not how they're getting the guns. We need to go after these people that are getting released on their own recognizance on prior felon in possession of gun charges, which is happening in California and happening coast to coast in this country right now. As we go, okay, well, we had a gun, big deal. Like, no, that is a big deal. And, until we get serious, that's going to happen. And people that are prior felons in possession of firearms who commit a zero bail crime are still going to get a zero bail regardless. And that's a problem. That's a major problem right now.
One of the things that I'm not sure about, and again, this is just my curiosity, I don't really understand what the big deal is with more gun laws, cutting back on the amount of guns that are available or the time limit before you can buy a gun, that sort of thing. Simply, and the reason I say that is because I think let's say myself, if I were to get angry with someone and feel that I'm going to have to go out and buy a gun in order to hurt this person, it just seems to me like I really don't need that. If I really am that angry and I'm really determined on hurting that individual, I mean, there are baseball bats, there are all kinds of things that are not normally considered. You don't get an extra crime for having that thing. You don't get an extra crime if you have a baseball bat, and it'll kill just as easily, just as fast. Meanwhile, if I'm a criminal, what do I care if they make a law saying I can't have one? I mean, I'm a crook, so it doesn't really matter. Why do people always use, let's add another gun law, let's make it harder to get guns, and assume that that's going to fix the problem?
It's ridiculous. I mean, it's irritating to me that, that we can have our president of the United States issue a press release and have a press conference and say his solution to that is that the attorney general is going to go after gun dealers. We all know they get them on the street. They don't get them legally. They get them illegally.
They're crooks.
And that's
of
the
course
point.
They're going to do it illegally.
And as soon as they start doing that, we need to hammer them and not let
Yeah.
them do that. But that's the answer. And nobody wants to say that, okay, it's a 15-year mandatory minimum if you have a firearm and you're a prior felon. They won't be doing that. And I think that we need to send that message as a society. That's the answer to this. And obviously to prevent people from going into a life of crime anyway. But, that's not going to solve our current problem. We have to hammer these guys. And that's, we're not going to hammer gun dealers and fix the problem.
Now, I want to ask you a question, but recognizing ahead of time, I don't know, you may be an attorney. Are you an attorney that, because I don't want to put you on. Okay. I mean, because this is a question that I should probably be asking an attorney. But I mean, the whole idea of anybody who commits a crime that happens to be a felony for one thing, they commit that crime, they go to jail, they do their time, they come back out, they spend, let's say, pick a figure, 10 years, 20 years as a good law-abiding citizen, but they can never own a firearm again. I don't understand the logic and the common sense to that, honestly, because it would seem to me that if a person is following and abiding by our laws, have paid the penalty that society has said you must pay for whatever you did, well, why do we hound that guy and prevent him or her from protecting their family from that point forward, from going hunting and enjoying the sport of, just target shooting or whatever? And the crime they committed had nothing to do with a gun. Maybe they wrote forged checks or stole a bunch of computers out of a store, whatever it was. It was a felony because of the dollar amount of the stuff they stole, but not because they used a firearm to do it, not because they committed a violent act against another person. I can understand it if my crime was one of violence, but if it was one of fiduciary, so I just did something to get me some more money that did not involve a gun, it did not involve hitting anybody, touching anybody. Why, who came up with the brilliant idea that that's going to stop somebody from doing whatever that is again?
Well, your federal government did, and it's an overreach. I agree. And the biggest overreach that's even bigger than that is what's called the Lautenberg Amendment, which most people don't realize that the lowest level domestic charge is a lifetime gun prohibitor. Example, real case I had was a guy that got into a domestic violence, disturbing the peace. It was an argument, and the neighbors called in a noise disturbance, and that was a lifetime gun prohibitor. And people don't realize that. And there's no exceptions. You can't go to federal court. You can't go to a judge. You can't get relief. And so I'm all about having a case-by-case analysis of, the guy, 15 years, you made a simple mistake. It wasn't a violent crime in the first place. You haven't done it again. Exception. And same with the Lautenberg stuff, is that, okay, a tumultuous relationship with this, and, somebody threw a cell phone, and I'm sorry, but, 5 years later, she's long gone, and you're paying alimony, and everybody's happy, and you want to defend yourself, or like I said, go target shooting. You can't do it. It's a lifetime prohibitor. So our draconian federal gun restrictions need work too, on the rights of citizens, including people that are previously convicted, because they do have a fundamental right to defend themselves.
Yeah. Let's take another short break. We'll come back and continue our conversation and find out a little bit more about Jeffrey Clayton too, because now I know you're a lawyer. So, but I believe you're also a writer, and I want to find out a little bit more about the kinds of things that you and that your coalition are involved in. And if you have a book out there on the shelves, we probably all want to take a look at that and find out what that book's all about. We're talking with Mr. Jeffrey Clayton. He's the executive director of the American Bail Coalition. And I'm Tony Lee, and this is The Law. We'll be back on KNZR.
KNZR presents The Law with Tony Lee.
Jeffrey, this is probably something I should have done in the very beginning so people kind of get to know you a little bit better. But tell us about you. Am I correct that you may have written a book or two here and there?
Well, I haven't written the first book yet. It's in process right now, which will be a good story we can talk about much later. I've published a lot of academic articles primarily. I began my career in Washington, D.C., working at the Department of Transportation. I went on to law school, and I represented unionized police officers. So I've seen it all in the criminal, justice system. Since then, really it's just been scholarship on this issue of catch and release from jail. That's been my expertise. And I've spent, almost a decade now doing that. I worked for two prior justices of the Colorado Supreme Court, worked on this issue, worked for the state probation department of Colorado for 5 years. So I've been around the criminal justice stuff primarily, most of my career, and I know it pretty well.
What was it that got you involved in the catch and release issue? That's something happened that just kind of lit a light bulb there.
Really, it was really, I was leaving government employment. I had become friends with a bail agent who was on a reform panel that I unfortunately was every Friday afternoon from 1 to 5 that I was required as part of my job to attend. When I left government service, obviously I was in the legislative world at that point. You get calls from various people, and one of the bail agents called and said, "We'd like you to think about representing us, not only at the Capitol, but also in the occasional Colorado Supreme Court case or other cases that came up." So I decided to do it, and it's been 10 years ago. So hard to believe time flies.
Time's fun when you're having flies. So I know most people say that the other way around. So then when you are working on these cases here in California, do you do them all across the nation, I would guess, do you?
Yeah, absolutely. We go to state legislatures from all around the country. We were involved in a lot of these cases, like the O'Donnell case where the bail schedule in San Francisco was litigated. We were involved in that one. And, Eric Holder was involved in a case down in Georgia we got into. So, we do it nationally. We work on is bail, and all I work on is bail. So if you want to talk to me about something else, I'm not a very exciting guy.
Well, bail in and of itself is, I think, a pretty interesting subject. What's the history of that? I mean, when did we as a nation start thinking that about, oh, give me some money and I'll let you out of jail and I'll hold your money. But if you don't show up, I keep your money. Where did that idea come?
It really dates back to the Magna Carta, which is, we're talking 800 years ago. The real interesting case in the history of bail is called the Four Knights case, which is really where you saw the right to habeas corpus and expanded right to get out of jail. And what was the reason? Well, the king was raising money for the war, and these four knights didn't want to pay. And they were in prison, and Lord Coke was their attorney, who was a famous, English scholar who was their attorney and who basically got them bail. And from that, the tradition of, you secure your release and you get out and you have a personal surety kind of began. In this country, it was kind of presumed there was a right to bail. It really started with the original Massachusetts Constitution and the Northwest Territories Act, which basically said all persons have a right to be bailable by sufficient sureties was the language. You didn't see commercial bail or for-profit bail regulated until the 1900s. Usually, if you wanted a friend to bail you out, they didn't want to do it. Obviously, you would pay them, but that would all be under the table. So that all obviously went on. But the movement west really created what was the compensated surety. The English Supreme Court said that was void against public policy. We're not having compensated bail agents in England. The U.S. Supreme Court, in an opinion written by Justice Holmes, said, yes, we are going to do that. And we are going to allow states to do that if they want to regulate it. And that, really in states like New York and stuff, it's really was to keep organized crime from co-conspirators from bailing themselves out. So bail is a long tradition. You can even read about bail in the Bible. It dates back for a very long time. And it's really just securing your release and, having some skin in the game that you'll be returned or that somebody else, a third party, will make sure that you're returned.
But it seems like, when you're dealing with people like the mafia, these big gang types, drug dealers, people that have $10,000, $20,000 sitting in a coffee can on the counter because that's their drug money. It would seem like if I get arrested and I've got that kind of money sitting on the corner, oh, what's $10,000? No big deal. And I'll take the rest and skip the country. What kind of guarantee is that I will come back and be there for trial?
It's not a very good one, and it happens where if you see defendants posting large cash-only bails, it's usually gang money. They wouldn't use a bail agent because they don't want us chasing them. They don't want Dog the Bounty Hunter arresting them, right, and chasing them around. They don't want that. And so in East Coast states, you have what's called a bail source hearing, where literally they have to go in and tell the judge where the money came from. And you see that a lot. In New York State, for example, a bail agent has to go post bail in open court, and the judge gets to ask him, hey, where'd this come from? Who's this guy? And so there is a kind of a backstop to that. California doesn't really do much of that, and they probably should.
We're going to take another quick break. We've got about 10 minutes left, so we'll spend that last minute working on whatever it is that you would like for the people to know, because I've asked you all of my little curiosity questions, and I'm sure you have a lot more information that you think the people ought to have. So we'll get to that in just a minute. Folks, we're talking with Mr. Jeffrey Clayton. He is the Executive Director of the American Bail Coalition. I'm Tony Lee. This is The Law on KNZR.
KNZR presents The Law with Tony Lee.
So what have we not talked about that would be really something that you would want the people to know?
Well, I think that people in this country need to fight for their constitutional rights. That your constitutional rights should not depend on who gets elected. And right now, that's kind of what I see happening. Is that, well, we want to impair the right to bail right now because, we want these people that we like to get out. We don't want these people to have to post bail. And I think in California, that's is almost what has happened is that, we say, well, this person can't afford bail. That's not fair. So we should get rid of it. Well, no, people need to focus on their core constitutional rights. In California, the Constitution does not say that we can detain people based on how dangerous we think they are in the future. And that is where this crossroads of mass incarceration began, which is we started saying, we think this guy's a bad guy in the future. And that's where all this has gone. And the California Constitution doesn't technically permit that analysis. And that's what people need to focus in on, is that if we protect the core constitutional right to bail, we'll have a better balance in the system than we do now. And the other thing I think that people don't realize in California is the imbalance in the bail system because of this thing called premium rebating, where, rebating has caused a race to the bottom and has jacked the bails up in California so high that we've got to do something about it. And California bails are so high, you compare them to New York, they're 10 times higher, 20 times higher, 30 times higher on the same charge. So that's, I think, what people need to focus on is constitutional rights, and let's get the bail system in a better balance to protect constitutional rights and make sure that people can get out, when they should.
Generally speaking, would you say that that is a question that only those involved in the legal profession are considering and the general public haven't really given it much thought, or is it the other way around?
The general public has not given this much thought. And I think in the election of Prop 25 election, I think we learned a couple of things. One, people like their right to bail and they want to keep it. They don't want to really change it. Two, they don't want a computer to determine it. And that's really what Senate Bill 10 was about, which was choosing winners and losers using this algorithm. They don't want that. They want judges to pick winners and losers, and they want their right to bail. And while they're sympathetic to the idea that some people can't afford bail, they're more in line of they just want their constitutional right to bail. I think we learned. And that's and your average person, they understand bail, kind of, they get it. They realize, okay, I'm putting it up. They show up. People kind of understand it. And it really just states, things like playing Monopoly, get out of jail free cards. And people kind of understand the way the bail system works, even though they really don't have too much knowledge of it.
Well, how does it work, though? I mean, in other words, let's say I get arrested. I've got a $100,000 bail. I heard you mention 10% earlier. So that means I give somebody $10,000. That's the bail agent. Now, what does he do with that? How does that help get me out of jail? Sure.
So, you have two options when the bail's $100,000. You can post the whole thing in cash, which obviously you lose money over time if you give the government cash. And if you get convicted, the government's going to keep it most of the time. So, you may have to make a judgment about whether you want the government holding your money. In California, because the bails are so high, almost full premiums almost never upfront. So, and it's negotiable. So a bail agent can technically charge zero on a $100,000 bail. So you have a very competitive bail market in California where on $100,000, well, the bail agent may say, I'll take 1% down, and you'll make payments and I'll rebate the rest so that the total premium is $5,000, for example. Could be an arrangement that's made out there. What does the bail agent do? They're on the hook for the whole thing. So we're putting up commercial paper guaranteeing the $100,000, that if you don't show up, we have to pay the full $100,000, or we have arrest powers, we return you to court. And that's what we want to do, right? Because we want to be a good corporate citizen. We want to make sure you're doing what you're supposed to. So essentially, we're taking a massive risk on you for an amount of premium that we don't refund, by the way. That's our fee for doing what it is we're supposed to do, which is, Families don't want to go to jails in the middle of the night to post bonds. Families don't want to deal with the jail. Families don't want to deal with that. And so it's, that's kind of the convenience factor and the fact that we're guaranteeing it, that it's a financial guarantee. And if somebody doesn't show, we're on the hook for the whole 100%, and there's, no way around it usually.
Mm-hmm. But you mentioned in some cases, the judge, if you put up the cash, the whole thing, the judge could actually keep that money. It's somehow that sounds illegal.
It's not. It's permitted in many states. I believe in California is one where if you're convicted of the original charges, then they can dip into your bail money, which I think is fundamental.
Mm-hmm.
Courts have said, well, under certain circumstances, or in some states, it's automatic. Like my home state of Colorado, it's automatic.
Mm-hmm.
They just, if you have anything out there, the bail money goes away. And so to me, that kills the incentive to appear if it's gone.
Exactly.
You go, well, they're going to take it anyway, so why bother? So I think that's why we outperform full cash for that reason. Is one, we have arrest powers, and two, people just assume it's gone. They look at it as a get out of jail fee rather than a guarantee.
Mm-hmm. And then the other thing you mentioned about the fact that it's there's a system of presuming that you're going to commit a crime in the future. That sounds like that goes against the Constitution.
It should. And I think, we had a wrongfully decided case by the U.S. Supreme Court that caused this creep of dangerousness and future dangerousness in the 80s, which is really what the federal system is, which is saying, do we think he's going to do it again? If so, his bail's high, we keep him in jail.
Mm-hmm.
And that has caused major damage to the system. And as Justice Thurgood Marshall said in dissent, it's the shortcuts we take to convict the guilty only harm ourselves and harm the innocent. And he's so right about that, is we have to wait until they do it, and if we do it before, we're damaging the innocent more than we are convicting the guilty.
Yeah, because you could literally walk up to anybody on the street and say, look, I think you're going to commit a robbery in 5 years, so you're in jail. I'm going to arrest you right now. What's to prevent something like that from happening?
Right. And I think that's why Proposition 25 died, because risk assessments do that. They say, well, we think this guy's X risk of doing it again. And people didn't want that. They think that destroys the presumption of innocence, I think, more so than, I can't afford bail and I have to stay in jail a few extra days.
Mm-hmm. So what is next for the State Assembly Bill 262? What goes next? Well,
on Tuesday, July 13th, which is this upcoming Tuesday, there'll be a hearing in the Assembly Public Safety Committee. Anyone can testify or listen to the hearing online. You can testify online if you want to, either for or against the legislation. The legislation will get out of that committee if it passes, and then it will go. It's called the Appropriations Committee.
Mm-hmm.
From there, it'll go to the full floor, and we expect it'll all be wrapped up kind of by mid-September.
I want to thank you so much for, first of all the work that you've done within the community and that you continue to do. But really, I want to thank you for coming on, spending this time with us and trying to help us understand the Senate bill that's out there that we're looking at and listening for, and also our part in that, our responsibility in that, because as we talked about, there may be a lot of folks who just kind of let things happen and don't see that they really have a vested interest in learning about it and getting involved with it and making their thoughts and their beliefs known and their desires known to the legislatures as to, what do they want to happen here. So thank you so much for all of that.
Absolutely. It's been a pleasure to be on.
It's been my pleasure having you, sir. And I want to thank all of you who have been listening too, and hope that all of this made a little bit of sense for you, that it clarified some issues for you, and that it gave you something to think about, because this country is ours. As I guess it was Thomas Jefferson that said after they came back from that convention, that we've given you a republic if you can keep it. And, we still have it. Let's see if we can hang on to it. Thank you, folks, and we'll see you next week.
KNZR presents The Law with Tony Lee.